Welcome to part three. I think we stopped at the Terry frisks and Terry stops, if memory serves me right. And we've ended up on a slide that basically gives a definition of a reasonable suspicion. Before I touch on that, I just want to go back to probable cause. Probable cause is a level of um, need, I guess, for lack of a better way to describe it, that law enforcement has to have that's at a higher level, okay? So basically, for probable cause, it's a set of facts and circumstances that a reasonable person has or would lead a reasonable person to believe that another has committed a crime. It's also necessary level of belief that would allow a police officer a seizure, aka an arrest, and also full searches of property, persons, etc. Well, when we get to a Terry stop or a Terry frisk, an officer does not need the level of belief or facts and circumstances as high as probable cause. What an officer would need is something called reasonable suspicion. And it's a belief based on a consideration of facts at hand and on reasonable inferences drawn from those facts that would induce an ordinary, prudent, and cautious person under the same circumstances to conclude that criminal activity is taking place or that it has recently occurred. And so basically, if an officer sees someone or some persons who appear suspicious, they have, their, I don't know, I guess it would depend on the time of day, the location, the behavior of the person, and that officer feels that they have either maybe they're out in a parking lot late at night looking into vehicles, and the officer believes that these individuals or individual has broken into cars or uh, is about to break into cars, that officer could stop and use reasonable suspicion, if they have it, to make some inquiry as to what is this person doing and even pat that person down to make sure that there is no weapons. This came from the Terry v. Ohio case from 1968, where an officer apparently had seen two or three individuals who looked as if they had been casing what I believe was a jewelry store at the time. The individuals were out at a specific time of day, evening. Just the facts itself made the officer believe, or he had some type of a belief, that some type of criminal activity had just occurred or it was going to be occurring. So he stopped these individuals and did a Terry frisk or a Terry stop, wanted to make sure they didn't have any weapons, and did in fact conclude that they had broken into some uh, business or were conducting some type of criminal activity. Um, the argument was, well, he being the officer, didn't have as much belief or knowledge as, say, probable cause. So when we talk about reasonable suspicion, it is a lower level of belief and knowledge of facts and circumstances than, say, probable cause. All right. You will hear this again later on when you take courses such as Policing in America, Criminal Law and Procedure, etc. All right, let's get to interrogation. Some people would call this interview, some people call it interrogation, some say it's interview and interrogation. But then interrogation is any behavior that a police officer should know is likely to elicit an incriminating response from a suspect. And this would include lineups, lying to a suspect, provoking comments, and eliciting information. Your textbook, well, you guys don't have it in your chapter because you don't have chapter 6, but my textbook states that in 2003, Illinois became the first state in the nation to require electronic recording of police interrogations and confessions in homicide cases. I'm not exactly sure how accurate that is because the state of Minnesota has always had a requirement that all felony cases be recorded electronically, whether it be audio and or video, primarily both if possible, um, and also officers who interview a suspect for even misdemeanor and gross misdemeanor level crimes have to have minimally audio recording of that interview. So why do we have due process requirements with regards to interrogation and or interview? Well, what it does is it protects both the officer and the suspect. It protects the suspect from any physical abuse, inherent coercion, or psychological manipulation that might be inflicted by the officer, but it also protects the officer from allegations and accusations of physically abusing, coercing, or psychologically manipulating a suspect during an interrogation as well. Right to a lawyer during interrogation. There are two landmark cases that have established the parameters for this. Escobedo versus Illinois, police had refused attorney access to the client and refused to let the defendant see his attorney. Also, then in 1966, we had Miranda v. Arizona, which established the Miranda warnings. Here's the deal. If you work as a police officer and you take somebody into custody and you start to interrogate them, if they say the word lawyer, you need to stop asking any more questions from that point on. Now, if you do stop and then the suspect starts to regurgitate, I don't know, incriminating information about himself or herself to you, well, then by all means, you can use that information because you did not elicit it. You stopped speaking, you stopped asking questions, but the rule now is anytime a suspect asks for a lawyer, it's always common practice to stop asking any more questions and get the attorney for that client. As far as Miranda v. Arizona, we're going to talk a little bit more here about what type of elements or requirements need to be met prior to, or I guess for Miranda warning to have to be read to a suspect. Here we are, required criteria. A lot of people think that when they are being questioned by an officer, that they automatically have to have their Miranda warning read to them. That's not true. If you are in fact in custody, let's say you're handcuffed, you're placed in the back seat of a squad car, you are being held in a jail cell, that type of thing, and then an officer begins to interrogate you, yes, you need to be Mirandized or have your Miranda warning read to you. Because if they don't, anything that you do say will not be used against you in, or cannot be used. It will be excluded. Now, let's look though at traffic stops. A lot of people have said to me, well, I didn't feel free to leave when I was pulled over for speeding. There is some court case law pertaining to a brief detention, okay? And traffic stops do not require Miranda warning to be read because you are only being detained for a short period of time. You are not in custody. So if you are being held longer than 20 minutes, a reasonable person would then feel they are being placed in custody. However, traffic stops themselves are considered to be brief detentions and should never be any longer than 20 minutes. Alrighty. So chapter 6, we'll just breeze through this real quick because I think there's maybe 6 slides on issues and challenges in policing. The police personality and culture. Obviously, police have their own subculture. Students have their subculture, faculty have their subculture. And in the police subculture, um, it's a set of informal values which characterize the police force as a distinct community with a common identity. And basically, that definition could be used for any type of subculture. Police working personality, if anybody here knows a cop, has met a cop, has been cited by a cop, you'll know that they have more of a cynical personality. They're very suspicious, could be prejudiced, individualistic, hostile, authoritarian. This kind of is something that develops as they work in the job for a very long period of time. And, they don't necessarily start out that way. Maybe the job itself creates those types of personality characteristics. Corruption and integrity. Well, police corruption is the abuse of police authority for personal and organizational gain. This is one of the most difficult dilemmas that officers confront. And I will say this, we used to hear a lot about the uh, very public, negative, uh, excessive force cases or police corruption cases. We don't generally hear too many of those, about too many of those today. But if you want to watch a very good movie about a true story, Prince of the City is a great movie that was filmed, I believe, in the late 70s, early 80s, and it stars a man named Treat Williams who plays an NYPD officer. He agrees to testify only if he could protect his partners. He had been busted, um, doing some corruption or doing something he shouldn't have been doing. But he was eventually forced to testify against all of his partners. And it really opened up a very big can of worms within the department. A couple of his partners ended up committing suicide, and it was again, it's a very gritty but graphic movie, and it's I think it's very well told. Let's see here. Who investigates the investigators of crime? I'm sure we're all familiar with the Internal Affairs Division. Not every department has one. Um, Smaller departments just don't have that type of staff. But when corruption in a department is so uh, gross or so widespread, you may have the Bureau of Criminal Apprehension here in the state of Minnesota come in, Post Board, which is our licensing board. Also, the FBI will step in and investigate for agencies that are so grossly, you know, corrupt, such as New Orleans PD and NYPD, and I believe actually LAPD at one time as well. Problem when officers cover up another's wrongs? Well, obviously that will decrease the credibility within um, law enforcement. And what's really unfortunate is during the 90s, with all of our high-profile corruption cases and excessive force cases, really the most devastating thing that could happen to this country was the only thing that really was able to turn around the credibility of law enforcement. That was 9/11. After 9/11, or prior to 9/11, law enforcement had a very big problem with credibility. A lot of citizens had fear and distrust of police officers. And after 9/11, police were then looked at as heroes. And so at this point right now, I think law enforcement still has a great reputation. And it's really unfortunate that it took something so devastating to create that or bring back that good reputation or credibility. Long-term ramifications on law enforcement reputation could occur when you have a bad incident. San Diego California Highway Patrol had an officer named Craig Pyre who was very well known in the community. He was sort of their morning traffic officer who was interviewed to, tell the public how to, you know, be safe and you know what I'm saying. He was officer friendly, talk about seatbelt laws and helmet laws. Well, one morning a young female's body was found dumped in a remote area and she had been strangled to death. And the next morning, Officer Pyre, was being interviewed by the morning media. And it wasn't until later that they looked at this film, and Officer Pyre had scratch marks on his face. And he did eventually confess to the homicide. And he was somebody who created such a negative impact in San Diego. The citizens were terrified of pulling over whenever any cop pulled them over for, say, speeding, equipment violation, you name it, because of Officer Pyre's uh, level of authority and the trust that citizens had in him, and ultimately what he did do to one of their citizens and how public it had become. I think it was about good 20, 25 years when people really started to trust the police again. And then obviously the LAPD Rampart Rodney King incidences that we discussed earlier. I'll leave these quotes for you, but NYPD had two very public corrupt eras. One was in the 1970s, one was in the 1990s. And again, these are quotes made by officers when they were being questioned by the Knapp Commission and the Mullen Commission. Both times the FBI had to step in and take over the department because of the widespread corruption within that agency. Is it still this way today? Well, in 2002, and I realize that's almost 10 years ago, research indicates that the blue curtain of secrecy is breaking down. There are several reasons or theories. One could say it's because more minorities and women are infiltrating the profession. Although I will say that it doesn't necessarily have to be just white males who create uh, you know, the corruption or participate in corruption or any of these excessive force claims. But another theory is that higher educational standards are being employed, higher hiring standards are being employed, and more restrictive candidate qualifications. But you got to look at it statewide. We still see several states out there who only require either a high school diploma or a GED in order to hire or in order to become a law enforcement officer. And there are still states out there that don't do background investigations and or psychological evaluations on their officers as well. Minnesota, however, we do both of those. And our Minnesota standards is established by the Minnesota Peace Officer Standard Training Licensing Board. This department establishes course objectives and requirements for schools in order to be eligible for licensing accreditation. So for any of you out there who are taking these courses in an effort to get into law enforcement and you think that the courses are much too rigorous, you can thank the post board for that. Also, law enforcement officers have a requirement of taking 48 hours of continuing education every 3 years after graduation and their state exam. And these CTEs, as they're called, will um, give you, I guess, training on legal updates and a variety of other things. Oop, I don't know what happened here. Sorry. So to get back to our very last slide, the last slide is other methods proposed to minimize misconduct. Who knows? College, college, college. I guess I am one of those people who has established the theory that the higher level of college may reduce the impact of corruption and unethical behavior by officers. Also, higher standards within an agency. Truthfully, shit rolls downhill. So if you have a chief or someone who is running the department who is unethical, who is corrupt, it's going to foster uh, how that agency is run. And those officers will basically, most of them will start to adapt or adopt that type of philosophy. Strict and fair discipline, proper recruitment, superior performances. We want to see leadership by example, higher pay, and better training. So, with that, it's the end of part 3, and I hope you guys have a great week. Thanks again, everybody.